And get it out of my system.
Yeah.
All right. Recording now, 7. The Honorable Judge Stephen.
Main Judge.
Here this morning in State versus Donna Adelson, 2023 CF 3226. For the final pretrial hearing this morning, we're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Josh Lozano for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motion in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Zalman?
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, or not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking the court exclude that file.
Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as to hearsay?
Well, relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markell, with no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
Well, as to any pleadings that correspond with emails or communications that were made by the defendant, otherwise demonstrate a role in some part in the divorce case. As to those, I'm going to rule that are admissible. The pleadings themselves should have been offered not for truth of the matter asserted, but to otherwise demonstrate no intent. Those are admissible. However, Ms. Cumberland, as to the birth of the file itself, and we believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. It is not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case. However, it was not an as substantive evidence. I do have to make clear on this point, Mr. Zellman, as to what the witnesses were testified to, and none of us reach this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, that might be not a part of the state's case in chief, may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on this?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion of limine concerning the testimony of Sir Yusuf. Mr. Salmon,
Again, Your Honor, we stand on the motion.
Mr. Carpenter's,
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
well, and I assume you are going to leave Miss Yusuf available as a better witness if necessary.
Yes.
If the witness is not going to be called, it essentially moves the issue. On that point, Mr. Salmon, the state is not permitting to call on this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Yusuf still is able to testify in that capacity. Well, the next motion of limine concerning the testimony of Stephen Webster. Does the defense have an argument that has not already been made through pleading?
No, Your Honor.
Ms. Kaplan in response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
All right, concerning the testimony of Mr. Webster. Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he will testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's very rather to have to get into what was being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to it. Was any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markell. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule for
statements made by the deceased to Mr. Webster. Ms. Catlin, do we have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markell to his attorney and offer my theory of admissibility prior to asking the question if I decide to do that in this trial. I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Well, during as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. Clearly reserve the ruling on the issue of any statements that he might testify to by the deceased, that the state, again, will have to present an actual setting to hearsay in which the matter can be placed before the jury. Right, the renewed motion and remedy concerning the Latin Kings. Mr. Zamba?
Yes, Your Honor. This goes in part to the theory of the defense, and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation as a group or testimony for that, but court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. It would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly, special agents. I believe it's Jimenez.
On the last trial, he outright testified that Rose, I guess, that was pretending or trying to influence your client to member after that became his gang. To that end, Mr. Chapman, what are you arguing?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think it's just got a character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to his painting on the character of Mr. Rivera specifically, and a negative light, the credit will make the same. As to the witnesses go, Mr. Jimenez or other witnesses that may present this topic unsolicited and their directs. Once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense of the cross-examined Mr. Rivera as to his role as a young member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover thief, this is where the analysis begins to diverge on this topic. He specifically employs the defendant as a Latin King member, correct?
No, sir. My recollection is, and I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. He guessed that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. And the idea was just, you're an associate of this killer who is a gang member.
The response when we have trial, which was lovely.
Just looking at his previous testimony. I'll quote from page 1067 of the trial transcript to Mr. Charlie Adelson's case. Part of Latin 20 question: can you explain what that operation was? Answer: my role in the operation, I was portraying a Latin King gang member, and I was instructed to conduct the buck. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member? The question you were posed. I did not. Okay. So you're just, that's the role. That was not role. You're a character. That is correct. That is his testimony. And yeah, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous year, last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang.
You know, that being said, this doesn't arose to your client's state of mind, clearly trying to establish that he knows the difference between upon the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Hanson.
As to the questioning of the former undercover officer, those young members will permit the defense to question the former speculation as to whether he was portraying a member of a specific gang as a part of his own operation. Depending on what the answer is, the issue of whether the name of the kings needs to be specifically part. As to either Mrs. Adelson or Charlie Adelson testified concerning her state of mind and knowledge of the Latin kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to the police review, the court's ruling will remain the same. As to his leadership role or specific affiliations, the fact that he is a gang member may be inquired to, and the fact that it was had. The fact that he was recruited in this case, that certainly is right for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Would we need clarification on this rule?
Just not fair.
Not from the state judge.
So the concern we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings before. That heightens her fear. And of course, she will testify.
I cannot make the testify if she was letting the dues fail as a part of her defense. That's her choice. But ultimately, someone with competent knowledge has to testify to this fact. There is no information about state of mind from the witness that either does not spoken to her client or either has no knowledge of the state of mind. I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time when she had an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under defense field. We would ask that he remain on the defense case so that we can call in on our case in chief.
That's fine. Mr. Rivera, as I call, never had any direct communication with your client, that this is to elicit another life matter.
That's correct, Your Honor. It would be once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin.
Very well. Mr. Rivera will remain under the defendant's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limit as to the interpretation of emails or clearly from emails and text messages. which witnesses is the defense referring to concerning this motion?
Your Honor, I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about code language. Code language is treated different. What we're talking about is the emails, the recorded phone calls, the text messages, other than coded language. What we're asking for, because it has come out so frequently, that the court, or that the state, and the gathering in the past, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used.
Response.
I agree. That would not be a miss.
The motion in eliminate it was granted. It was the rose and the argument that was matter in matters that would go to a code in which a witness could have had a proper foundation on this issue. Certainly, they may testify as to that point, but in the general opining as to what an email, a phone call, or a text message means, will not be permitted unless there is a proper foundation that can be loaded by that witness. That's the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court previously ruled on this issue and that allowed the state to use this information of argument. The new information as I've laid out, paragraphs 4, 5, 6, and 7. I stand on the motion. Those additional pieces of information have not previously provided report, and I think that it's significant because it goes to her state of mind for making the travel. For example, going to the airport and for stepping on the jet.
And the calling by counsel's already been correct, or if it's read about the fact that the resume with the process, subpoena, or warrant for your client, correct? So, response was coming.
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular plan, has reviewed the transcripts of the rendition that were stated by her in this motion, and the ruling we were known to send that was issued as before. The matter to go to the weight of the evidence and not with admissibility. The jury, as the trier of fact, is going to decide what significance give to the evidence. The defense also is free to cross-examine issues that pertain to Mrs. Adelson being free to travel. The matter is open previously rose within the motion to suppress and rule in as to the phone calls and other evidence that also will be presented to the jury as well. They will make up their mind. When I believe that covers the defense motions. This time I understood that it's did not have it and that the windows that not have been previously written about.
Pass spectrum.
Judge, there's one additional one, also filed on July 21st, concerning the opinion testimony of Jason Newland and Patrick Sanford.
Oh, yes. No, that motion.
I'm sorry. I'll stay on the motion.
I want a response.
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Witness Cameron, even though it might be required to a deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised out.
Of course, there's no reason to elicited a deposition, and it could never be admissible at a trial. So we're just wasting paper and time. These motions. No objection.
But the state is considering the issue in the motion made as to the opinions that will be offered by an investigative bureau or special agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. And we're going to see a context in which this might come around either in that or as far as impeachment. But again, these rulings are being made as to states, the substantive evidence the state may present as a part of its case in chief. It needs to be readdressed as a matter of impeachment and that's take it out at the appropriate time. Let's go ahead and talk through some of the logistics for your selection on page 19. We have around B in this program. I believe the number of jurors that we have under Simmons right now, the respective jurors under Simmons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of jurors of the issue at a pre-trial publicity, similar to what we did in the last trial, where we'll be asking these same questions or essentially the same questions. But the parties will have an opportunity to follow up on those questions and the issue in pre-trial publicity. Then a respective juror is deemed suitable to return for a group review. From there, they will be given a date and time for which group review will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from the left going through the pre-screen process. Anyone who has had an issue or either the third believes the state believes and defense believes is not suitable to go to the group review, from where each party will have an opportunity to make their objections known as to that respective juror, and I will be told for the time they're going to be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. And so, as well, so that we don't have any issues similar to that occurred in the previous trial, in which I believe the allegations the jurors were speaking to each other, we're going to have additional photos. The respective jurors are going to be instructed not to speak to each other. It might make it longer for them, but they will be sitting silent or provide reading material to them. And we'll have extra barrels on hand to ensure that no one is speaking to each other while they're awaiting to be screened. Does anyone have anything they need to raise in certain way?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down at jury assembly?
I believe last time, I'm not sure if someone else verified or not, but for each group that will be verified, I will do it personally so that we're from beginning to end. They're seeing me, sure me, and understanding. You're about to discuss the case or anything else with each other.
Perfect. That's the state's request.
Judge, how many of your 300 are coming each day?
Broke it up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping together if we were able to go through the pre-screening process and the issue of pre-trial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
If we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
We defensively plus 3 on it.
Then what we have are 12 jurors and 3 alternates at that time. We'll swear them. If we have enough time to actually move into voting on that same way at the selection, we'll do that so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario, it's 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Did bring up one calendar. Assuming that we have a jury by February the 22nd, then we'll have in place August 25th through September 7th as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes.
There and down to work and Labor Day.
Jackie is.
Okay, I need one other gun. I'm going to make him that side of the table. Who's the next? It was a holiday for the workers of the world. I cannot forget that we have to fill out the twin. All right, 825 through 9-2 limit. So estimating as it states case in chief, how long will the defense estimating to present on the choice that it wishes to do so?
Can I weigh on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if your honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings, only does the defense have position inside of us.
We don't want to make the openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer the opening to your place, you just don't want to open on the same day.
Going to depend, Judge, on your ruling on the additional motion.
Cool, right? And that now, again, depending on your time-wise, I'll just instruct both parties to be prepared, potentially give their openings. Not having place time in that plan with opening statements. But obviously, each party will be the captain of its own ship as to how we will captivate the jurors. Is either party stepping back over the wrong for minutes?
Depends on your ruling, Judge.
Let's go.
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how it was. I'd say 30 to 45. That's comfortable range.
Well, as to the defense case, once we are done with the state's case, how much time are you estimating?
Depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. That would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of that, I believe we will have rooms available for our family members, both for the victim's family and for the fellow who families anticipate making use of these rooms.
Yes, Your Honor.
Yes, sir.
Right. in contact court administration. From there, you'll receive information as to how to access the rooms. And then they will be made available.
Judge, can I clarify your intentions about when to start testimony?
And
You intend to start testimony on the 25th. Is that right? With the possibility of openings having already been conducted.
well, at the latest, if we go into Friday, we'll be able to select a jury.
Okay. If we get a jury,
If we're going to do why don't you that Friday and Saturday 21st? Well, point, there's nothing preventing the testimony from getting started for 1 second.
okay. So I'll be prepared to start testimony on the 22nd then. And my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th. Is that right?
I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right. So we could potentially go through the week of it.
It would be.
All right. I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not it.
We are losing a day because of September 1. If it need be, we can figure out what is the way we can make this work for our Saturday. Continue working. So you would like a break, but I'm here. As far as having matters of logistics, the way is concerned, done.
Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large. And probably someone in the back row could see what I have on my computer. So we're going to need to have, I understand we're blocked by this column, but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And like press and hold, you got to hold it down or it continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can put it, push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in opposition, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, but no understanding concern that we're registering with this. Now, inquired when to be done for the microphone filter, when the client that doesn't leave the light things down, so that way nothing's being away. That might be the easiest way for that. We have it, but that repairs the microphone. The seat is set up in the gallery. I believe the first 2 rows behind the fence. Those are not going to be relevant to any members of the media. So as far as the front side of the computer, if you need to put really how you will see that it's good, so you need to see on the far left, my right, your left. So that way your computer can face the ball and then you can see it. I don't live in there any holiday with us. Only that size beyond that.
The end of the table doesn't, it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
What I tried to recode the first degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here, and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this.
Right. We never last year and we Adam and Emily would figure out the best way to have a completely fails. Adam and when the revenues are coming out of it, where the states was going to used to build that it's that a little bit
Yes, sir.
because of that equipment, how them would be set out tables and how they figure it can't interfere with that, and we'll try to accommodate that as best as possible. And as to the audio and visual needs of the state, other than that has been used before with the audio setup, is there anything that needs to be addressed?
No, sir. It'll be the same setup with the same company.
Right. Probably when they'll need to get started by the 13th in this room, so we can set up that equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. For the immediate presence that would be here as well, I believe it would be similar rules to been in the past. There would be one live video camera, there would be one still frame camera. Obviously, there would be bloggers and reporters. They are committed to take notes as they work at jails. That the initial road behind the state was calculated, I assume the victims' families wishing to report.
Yes, Your Honor.
All that they received priority seating with regard to how they would wish it in the gallery. After that, it will be free to the public and press to seat in all areas that are available. Because I would probably need to those concerning those.
Your Honor, we also need space for our client's family as friends who are be coming to support her as well. You request that they have for priority seating.
That's what the two rows will be behind and the fence that will be available to a friend for. Again, similar to the last trial, other than the video recording and still frame photography, recording beyond that, no cell phones are to be out recording any other matters. They were trying to take photos of the witnesses or the jurors. I believe some of that in the last trial when Inspector Agent Jimenez testified. His face was not shown, obviously, because of the nature of his past work. The court rep using the same ruling concerning that as well. His face is not to be shown, but of course, the substance of his testimony certainly may be recorded on by anyone who believes it is newsworthy. During the selection of the jury, the witnesses of the respective jurors are not to be shown, their names are not to be shared. But as far as any biographical type of data, such as the composition of the jury, being red members, 7 male, 5 female, what their defendants are, those are certainly able to be reported on by the members of the jury and similarly, the prison room that we're talking about, given that those names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
They're not. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us. So that's another reason why we need that additional table. She also may have some additional people assisting her. And I'll make sure that they're identified at the bailiffs so that there are no issues there.
The members that would have support staffs may sit on the benches that are behind the attorneys or implement to figure out a type of configuration for them if we have the space. That would have support staff is permitted as to both sides. There was either party would have anything further grow concerning the visits of trial or any other issues before we finish.
No, Your Honor.
There you are. So, one other method comes to mind of the charters with Lupa. When with those matters having been discussed, we will be in recess for today. The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified, and then we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Thank you, Judge.
to reserve 1 day.